6 weeks after her mother's funeral, Sandra drove back to the house she grew up in, the one her mother, Carol, had spent 37 years paying off, $340,000 in equity. No mortgage, no debt, just a house that was supposed to be hers now. There was a letter waiting in the mailbox. Oregon Department of Human Services. Sandra opened it in the driveway. Pursuant to ORS 416.350 and federal law under 42 U.S.C. section 1396P, the state of Oregon hereby asserts a claim against the estate of Carol M., deceased, for Medicaid long-term care benefits paid on her behalf. Total claim, $197,604. Sandra read it 3 times. Then she called the number at the bottom and asked if there had been a mistake. There hadn't been. If you own a home, you're over 55, and you're planning to use Medicaid if long-term care becomes necessary, this program has your address. That's not a figure of speech. I mean that literally. The Medicaid Estate Recovery Program is triggered by 3 conditions. You received qualifying Medicaid long-term care services, you were 55 or older when you received them, and you owned property in your name when you died. If all 3 are true, the state files a claim. Not maybe, not in extreme cases, as a matter of federal law. And here's who that describes. It describes the generation that did everything the responsible way. You didn't blow your savings. You bought a house. You made the payments. You paid it off. You kept it in your name because that's what you were supposed to do. Your home is probably your largest asset, maybe your only substantial asset. And you assumed reasonably that it was going to your kids. What nobody told you, so not at the closing table, not at the Medicaid application window, not in any piece of mail from any government agency, is that the moment you receive Medicaid long-term care after age 55, the state begins tracking every dollar it spends on your behalf. And after you die, it comes back for it. Think about what that means in real numbers. Medicaid currently covers roughly 2/3 of all nursing home residents in the United States. The average private room in a nursing home runs $10,978 to $11,294 a month right now. That's over $130,000 a year. The average stay isn't a few weeks. It runs well over 2 years for most people who need skilled nursing care. Do that math. 2 years at $130,000 is $260,000 against an estate that, after a lifetime of spending down assets to qualify for Medicaid, consists almost entirely of one paid-off house. That's not a partial claim. That's the whole inheritance. Gone. And the reason this catches people completely off guard is the way Medicaid presents the home during the application process. When you apply for Medicaid long-term care, your home is listed as an exempt asset. It doesn't count against the $2,000 individual asset limit that Medicaid imposes. So you qualify. The home is safe as far as the application is concerned. What the application doesn't tell you, what no one volunteers, is that exempt from the eligibility count is not the same as protected from recovery. The state simply waits. It cannot touch the home while you're alive. But the moment you die, the clock stops and the bill comes due. That gap between what exempt means at application and what happens at death is the thing nobody explains. It's the thing that puts a $197,000 claim in a mailbox 6 weeks after a funeral. If you have a parent over 55 who owns a home and is anywhere near the point of needing long-term care, stop this video right now and share it with them. I'm serious. The window to do something about this closes, and I'll tell you exactly when. But it doesn't close today. Share this first, then come back. Now, before I show you the mechanism itself, the actual federal program, how it was created, and how states use it, I need to tell you about the move that almost every homeowner makes when they hear about this for the first time. The instinctive move, the one that feels like protection, because it's probably the most dangerous mistake in this entire conversation. And I'm going to cover it after I explain what you're actually up against. The program that sent Sandra that letter has a name. It's called the Medicaid Estate Recovery Program, MERP. And the first thing you need to understand about it is that it didn't come from your state. It didn't come from a governor who decided to get aggressive with retirees. It came from Congress. In 1993, the federal government passed the Omnibus Budget Reconciliation Act. Buried inside that bill was a mandate. Every state in the country must operate an estate recovery program for Medicaid long-term care costs. It's codified at 42 U.S.C. Section 1396P. That means it's not a policy someone can vote out at the state level. Every state runs this program because federal law requires them to, all 50 of them. It has been operating quietly for 33 years. Here's exactly how the trap closes. You apply for Medicaid long-term care. You're 55 or older. Your house is listed on the application as an exempt asset. It doesn't count against the $2,000 asset limit. You qualify. Medicaid begins paying. Nurse and facility costs, home and community-based care, related hospital bills, prescription drugs. Every dollar that flows out of the Medicaid program on your behalf gets recorded. The state knows to the penny what it's spent on you. Then you die. Your home is now part of your estate, and the state, which has been keeping that running total the entire time, files a claim against the estate for every dollar it paid on your behalf after age 55. Not a lien while you were alive, not a warning letter while you were still in the facility. A claim after death against the house your family expected to inherit. That is the mechanism. It's automatic. It's legal. And it's been sitting in federal statute since before most people reading this owned a smartphone. Now here's where it gets worse, because what I just described is the federal floor, the minimum version of this program. Roughly 2/3 of states, about 37 of them, have expanded MERP beyond what federal law requires. And that expansion is what turns a bad situation into a devastating one. The federal mandate covers what's called the probate estate, property that goes through the court-supervised process after death. But expanded estate recovery states go further. They pursue assets that would otherwise pass directly to heirs outside of probate entirely. We're talking about jointly owned property with right of survivorship, assets held in certain living trusts, annuity remainder payments, life insurance proceeds in some cases. In roughly half the states in this country, MERP doesn't stop at the courthouse door. It follows the asset wherever it goes. And the scale of what this program collects is not trivial. In the last year for which full federal data was compiled, states recovered $733.4 million through MERP in a single year. That's not a rounding error in the federal budget. That's $750 million coming out of estates that families expected to inherit. The home is almost always the primary target. Here's why. Medicaid requires recipients to have essentially no countable assets, $2,000 for an individual in most states. So by the time someone dies on Medicaid, they've spent down nearly everything. The savings are gone. The investments are gone. What's left in the vast majority of cases is the house, the one thing that was exempt during eligibility, the one thing the family was counting on. Drop your state in the comments right now, because how aggressively MERP operates and which assets it can reach varies significantly depending on where you live. Some states pursue only the minimum the law requires. Others go after everything they legally can. You need to know which category your state falls into, and I want to see where people are watching from. Now, I told you there was an instinctive move that almost every homeowner makes when they first hear about this. The move that feels like the obvious solution. I need to show you exactly why it backfires, because if you've already made it, or if you're thinking about making it, what I'm about to say could save your family's inheritance. When people hear about MERP for the first time, they go through a predictable sequence. First, disbelief, then anger, then, almost immediately, a solution. And the solution that comes to mind is usually one of three things. Put the kid's name on the deed, set up a trust, or just give the house away now, while there's still time. All three of those instincts are understandable. All three of them can blow up in your face. Let's go through them one at a time. The first move, joint titling. You add your adult child to the deed. Now it's owned jointly, with right of survivorship. When you die, the home passes directly to them. No probate, no court process, no estate for the state to file a claim against. Clean and simple. Except in roughly half the states in this country, it isn't clean at all. Remember what I said about expanded estate recovery. The states that go beyond the federal probate floor, in those states, jointly owned property with right of survivorship is explicitly reachable. The home transfers automatically at your death? Yes. And the state's recovery claim follows it. The title changed. The liability didn't. Your child now owns a house with a six-figure government claim attached to it. And they had no idea when they signed that deed. The second move, a basic living trust. You've probably heard that a revocable living trust is a smart way to avoid probate. And for many estate planning purposes, it is. But a revocable living trust is not a Medicaid protection vehicle. In expanded recovery states, the assets inside a revocable trust are still considered part of your estate for recovery purposes. The trust was designed to streamline the transfer of assets to your heirs. MERP was designed to intercept exactly that transfer. In those states, setting up a basic living trust to avoid MERP is like locking your front door and leaving the back door wide open. The third move, and this is the one that doesn't just fail, it actively makes things worse, is giving the house away before you need Medicaid. Just transferring it to your kids now while you're healthy, while there's time. It feels like the most logical move of all. The house is out of your name. It can't be in your estate if you don't own it. Here's the problem. Medicaid has a 5-year look-back period, 60 months. In 48 states plus Washington, D.C., any asset transfer you make in the 5 years before applying for Medicaid is subject to scrutiny. If you gave away your house or any asset of significant value, inside that window, Medicaid treats it as a disqualifying transfer. Not only does it potentially fail to protect the house from recovery, it can impose a penalty period that delays your Medicaid eligibility entirely. We're talking about a scenario where you need nursing home care. You've already given away your house and Medicaid tells you you're not eligible for a penalty period that could run months or even years because of the transfer. You gave away your home. You can't get Medicaid. And you can't afford the nursing home without it. That is not a hypothetical. That is what the 5-year look back was specifically designed to prevent. And it catches people who thought they were being proactive. The moves that feel like protection are the ones most likely to create a second crisis on top of the first one. Because MERP isn't a loophole someone forgot to close. It's a federal program with federal teeth. And the look back period is the mechanism that catches late stage planning before it can work. So if joint titling doesn't reliably work, and a basic living trust doesn't reliably work, and giving the house away too soon can actually disqualify you from the benefits you need, what does work? There are real answers to that question, lawful answers. Answers that are specifically designed to survive the look-back period, survive expanded estate recovery, and actually protect what you've spent a lifetime building. But they require time, and the window to use them is not unlimited. Here's what nobody in this conversation ever told Carol. There are exemptions built into federal law that block estate recovery entirely. Not workarounds, not gray areas. Hard-coded federal protections that every state must honor, no exceptions. Let's go through them. The first one is the spousal protection. If you are survived by a spouse, the state cannot pursue estate recovery while that spouse is alive. Full stop. It doesn't matter what state you're in. It doesn't matter how aggressive that state's MERP program is. A surviving spouse is an absolute shield. The claim doesn't disappear, but it cannot be collected while they live. For married couples, this is the first line of defense, and it's ironclad. The second exemption, a surviving child under 21. Recovery is blocked. The third, a blind or disabled child of any age, also blocked. These are federal floors. Every state must honor them. Now here's the one that most families never hear about. And it may be the most powerful exemption in this entire list for the people watching this video. It's called the caregiver child exemption. If you have an adult son or daughter who moved into your home, not visited, lived there for at least 2 years immediately before you entered a nursing facility, and who provided care during that time that allowed you to stay home rather than institutionalize earlier, that child can keep the house. The state's recovery claim is blocked. The home transfers to them, protected. Think about how many families that describes a daughter who moved back in at 45 to help an aging parent, a son who gave up his apartment to be there full time. These adult children provided real care, care that delayed or prevented institutionalization, and federal law rewards that with a specific concrete protection. But families don't claim it because they don't know it exists. The Medicaid caseworker doesn't lead with it. The estate recovery letter doesn't mention it. You have to know to ask. There is also a sibling exemption. If a sibling has an equity interest in the home and lived there for at least 1 year before you entered a care facility, their interest in the property is protected from recovery. Same logic. Real presence. Real stake, federal protection. And finally, every state is required to offer an undue hardship waiver. If a state recovery would deprive your heirs of their primary source of income or leave them without housing, the state must have a waiver process. The standards vary. It is not automatic, but it is real. It is available, and in Carol's case, it's exactly what saved the house. If any of those exemptions apply to your family, a Medicaid planning attorney can help you document and assert them. Don't assume the state will apply them for you. They won't. Now. The exemptions protect people who already qualify. But what about everyone else? The people who don't have a caregiver child, whose spouse has already passed, whose kids live across the country. What can they do right now while they're still healthy to protect a home they've spent decades building? This is where the 5-year clock becomes the most important number in this conversation. There are 3 planning strategies that actually work against a MERP. All 3 of them require being initiated at least 5 full years before you apply for Medicaid. That's not a suggestion, that's the look back period. If you start any of these inside that window, you may trigger the exact disqualification problem I described in the last section. The clock starts the day you act, not the day you get sick, not the day you need care, the day you sign the paperwork. The first strategy is the Medicaid Asset Protection Trust, an MAPT. This is an irrevocable trust, which means once you transfer the house into it, you've given up legal ownership. That's the trade, but you retain the right to live in the home for the rest of your life. And because you no longer legally own it, it is no longer part of your estate at death. Once 5 years have passed from the date of transfer, the look back clears. and the home is beyond MERP's reach, it cannot be claimed. It passes to your beneficiaries intact. The second strategy is the life estate deed. You deed the property to your children now, but you retain what's called a life estate, a legal right to live in the home until you die. At your death, the home passes directly to your children outside of probate. In states that use only the federal minimum recovery, the probate-only floor, this sidesteps the recovery claim entirely. The home never enters your probate estate because you transferred the remainder interest years ago. In expanded recovery states, the protection is less certain, which is why knowing your state's specific rules is not optional. It is the first thing you need to find out. The third strategy is the Lady Bird deed, sometimes called an enhanced life estate deed. It's only available in 5 states right now: Florida, Michigan, Texas, Vermont, and West Virginia. But if you live in one of those states, it's worth understanding. A Lady Bird deed gives you everything a standard life estate deed does. The home transfers at death outside of probate. But it adds a critical flexibility. You retain the right to sell the property, mortgage it, or change the deed entirely without your beneficiary's consent. You're not locked in. If circumstances change, you can undo it. That flexibility makes it a stronger instrument than a standard life estate for people who aren't sure about their long-term plans. Now, and I want to be direct about this, every one of these strategies plays out differently depending on your state. What protects a home in Texas may not protect a home in New York. What works in a probate-only recovery state may fail in an expanded recovery state. The strategies I've described are real. They are used, they work. But the specific version that applies to your situation requires someone who knows your state's rules in detail. A Medicaid planning attorney, not a general estate planning attorney who handles wills and trusts. A specialist who works in Medicaid planning specifically, because the technical distinctions in this area are not small and they are not forgiving. Are you an adult child who moved in with a parent to help with care? Tell me about your situation in the comments, because the caregiver child exemption is one of the most underused protections in federal Medicaid law. And if it applies to your family, you need to know that before an estate recovery letter arrives, not after. The strategies exist. The exemptions exist. The protections are real. But every single one of them requires one thing that cannot be manufactured after the fact: time. And I want to tell you exactly how much time you may have left and what happens if you run out of it. Let me put the full picture in front of you one time in plain numbers so there's no ambiguity about what's at stake. The average private nursing home room costs $10,978 a month right now. If you spend 2 years in a nursing facility, and 2 years is not an outlier, it's close to average for people who need skilled nursing care. That's $263,472. Medicaid pays that bill, and after you die, it files a claim against your estate for every dollar of it. If your estate is your house, that claim doesn't take a piece of the inheritance, it takes the inheritance. The house your family watched you pay off over 30 years gets absorbed by a recovery process that most of them have never heard of, to repay a program they thought was a benefit with no strings attached. That is what's at stake, not a bureaucratic inconvenience, the house. Now, I want to address something directly because I know some people watching this are aware that there's a bill moving in Congress right now. It's called the Stop Unfair Medicaid Recoveries Act, House Resolution 6951. It was introduced in January of 2026. It would, if passed, significantly restrict or eliminate Medicaid estate recovery in certain circumstances. And I want to be as clear as I can possibly be about this. It is not passed. As of right now, it is a legislative proposal. MERP is fully operational in all 50 states. Do not adjust your planning timeline based on a bill that has not cleared Congress. This program is 33 years old. It has survived administrations of both parties, budget fights, and reform proposals before. Until federal law actually changes, the program runs exactly as I've described. Do not wait for Congress to fix this. Now, here's the part of this conversation that I need you to actually act on. Not bookmark, not come back to, not mention to your spouse over dinner and forget about by the weekend. Act on. 3 things. This week. The first, find out your state's specific MERP rules. Specifically, whether your state uses expanded estate recovery, whether it pursues assets beyond the probate estate. That one fact changes everything about which strategies are available to you. Your state's Medicaid agency website will have this. A Medicaid planning attorney in your state will know it immediately. This is the foundational piece of information you need before any other decision gets made. The second, look at your deed. Right now, is the home in your name alone? Is it jointly titled? Is it already in some kind of trust? Each of those answers puts you in a different position. Jointly titled in an expanded recovery state is not the protection most people think it is. Already an irrevocable living trust may not be protected either. You need to know what you're actually holding before you can know what to do with it. The third, contact a Medicaid planning attorney. Not when care becomes imminent, not when the diagnosis arrives, now. Because the only tool that makes any of the strategies I described actually work is time. Specifically, 5 years of it. If you are 60 years old and in good health today and you start the planning process this year, you may clear the look-back window entirely before you ever need Medicaid. If you wait until you're 67 and your health is declining, the window may not close in time. The look-back period doesn't care about your circumstances. It runs for 60 months from the date of transfer. That clock starts when you act, and it cannot be backdated. The difference between acting at 60 and acting at 67 is not a matter of degree. In many cases, it is the difference between protecting the house and losing it. If you found this video useful, Achua, and I hope you did, hit the like button right now. It sounds like a small thing, but it's how this information reaches the people who need it before it's too late rather than after. Share this with anyone you know who owns a paid-off home and is anywhere near retirement age. They almost certainly have not heard of MERP. Most people haven't. That's the whole problem. I want to bring Carol back one more time because her story doesn't end with that letter in the driveway. Sandra didn't hang up the phone after that first call with the Oregon Department of Human Services. She called an elder law attorney the same afternoon. Not a general estate attorney, a specialist, someone who worked Medicaid cases specifically. That attorney told her 2 things. The first, Oregon offers an undue hardship waiver, a formal process by which heirs can petition the state to reduce or eliminate a recovery claim when collection would cause genuine financial hardship. The second, Sandra qualified. The house was her only significant inheritance. She had no other assets that would cover a $197,000 loss. The documentation process took 3 weeks. The waiver was approved. The claim went to 0. The house stayed in the family. Sandra got lucky. Not because the waiver exists, but because she found someone who knew it existed in time to use it. Most families don't. Most families get that letter, assume it's final, and start talking to real estate agents. They don't know there's a process. They don't know there's an attorney who can fight it. They don't know because nobody told them. Not at the Medicaid application window, not in the welcome packet from the nursing home, not anywhere in the official paper trail that followed Carol through 18 months of care. That is the gap this channel exists to close. The Medicaid Estate Recovery Program is real. It is federal law. It has been collecting from estates since 1993, and it will keep collecting until Congress changes it, which, as of right now, has not happened. But the exemptions are also real. The planning strategies are also real. The 5-year window is real. And for many people watching this right now, it is still open. The rule that threatens your family's inheritance has been sitting in the federal code for 33 years. The law that gives you a way around it has been sitting there just as long. The difference between the families who lose the house and the families who keep it is almost never income or luck or connections. It's information. Specifically, whether they had it early enough to do something with it. You have it now. The clock starts when you act, not when you get sick, not when the nursing home conversation becomes unavoidable. When you act. If that's today, then today is the right day to make the call. This video is not financial advice and it is not legal advice. It is a warning documented in federal statute about a program that has been quietly doing its work on paid-off homes for 3 decades. Take it to a Medicaid planning attorney in your state. Let them tell you where you stand, and then act on what they tell you. If you want to see more of what this channel covers, the rules nobody explains at the closing table, the programs that run quietly until they don't, subscribe. Every video we make is built on the same foundation. Accurate information delivered before it's too late to use it. That's the whole point for Carol, for Sandra, and for every family sitting on a paid-off home right now, assuming it's safe. It can be, but you have to move first.